Hello candidates, I am going to dictate you a passage from Legal Progressive magazine. So please get ready for the dictation. The dictation will start after 15 seconds. This appeal is directed against the judgment and order of the Delhi High Court by which it allowed the appeals of the two respondents, set aside the judgment and decree passed by the trial court, and permitted the appellants to file their written statements within 4 weeks from the date of the judgment, directing further that the trial court would then proceed with the suit and dispose it of in accordance with law. The appellant Messrs HDFC instituted a suit under Order 37 of the Code of Civil Procedure 1908 for realization of its dues against defendant number 1 and the two respondents who were the guarantors to the loan. According to the case of the appellant plaintiff and defendant number 1, who was the owner of a plot of land, approached the appellant plaintiff for a loan for constructing a house on the plot. The loan was sanctioned. Defendant number 1 executed the loan agreement and a promissory note in favor of the appellant. In addition, defendant number 1 also created inequitable mortgage in favor of the plaintiff by depositing the title deeds of the plot in question. The other two defendants, respondents before this court stood guarantee for repayment of the loan and executed the letters of guarantee. On the execution of the necessary documents, the loan was disbursed to defendant number 1 in 2 installments. The loan amount, along with interest at the rate of 15% per annum, was to be repaid in equalized monthly installments over a period of 180 months, and in case of default, according to the terms of the loan, the outstanding would attract additional interest at the rate of 18% per annum. The defendants defaulted in payment of the EMIs, and as a result, a large sum was outstanding against them. The defendants did not pay the installments despite letters and reminders. Hence, the plaintiff invoked the guarantees and intimated the two respondents that in case of failure to make the payment, legal proceedings would be instituted against them. Despite the aforesaid letter and legal notices sent on behalf of the appellant, the defendants did not pay the outstanding amount of rupees 4 lakh, and the plaintiff was thus left with no option but to institute the suit for realization of its dues from defendant number 1 and the guarantors of the said loan as such.